This is the City of Englewood special meeting. We're in the Municipal Court Building. It's July 20th, 2023, and it is 7:34 in the evening. Could we please all rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Yancy, could you please read the statement regarding the Open Public Meetings Act?
This meeting is called pursuant to the provisions of the Open Public Meetings Law. Notice of this meeting was included in a notice sent to the record and advertised in said newspapers on July 17, 2023, posted on the bulletin board in the municipal building, and has remained continuously posted as the required notices under the statute. A copy of this notice is and has been available to the public and is on file in the office of the municipal clerk. The purpose of the meeting is to discuss and review the city's COA affordable housing obligations. The council reserves the right to discuss and act upon such business as may be brought up for consideration to the extent that consideration of such public business is not known at this time, and reserves the right to go into closed session during this meeting to discuss items permitted under the Open Public Meetings Act. Formal action may or may not be taken. Proper notice having been given, the municipal clerk is directed to include the statement in the minutes of this meeting.
Thank you, Yancy. Roll call.
Councilman Cobb? Councilman Wilson?
Present.
Councilwoman Wasatski?
Present.
Council President Marin.
Here.
Also present is Mayor Michael Wilds, City Manager Robert S. Hoffman, Co-Attorney Edward Buzak, Planner John Zabo. Absent with prior notice is Councilman Ken Rosenzweig.
Okay, thank you, Yancy. Before we start this meeting, I have a statement to make that I hope will make things clear about the purpose of this meeting. Tonight's council meeting is a public presentation on affordable housing. The meeting is not the public hearing on the overlay ordinance. That hearing is scheduled legally for August 8th, 2023, and needs to be conducted at that time, not tonight. There are strict procedural steps that must be followed in enacting land use regulations, and one of them is that public comment on the ordinance must take place on the date and at the time and place set forth in the public notice for consideration of the overlay ordinance. Tonight's presentation is on the process, the timeline, the history/backstory as to how Englewood got to where we are in the affordable housing arena. Special Counsel Ed Buzak will provide an overview of the timeline that the city has been operating under. Affordable Housing Planner John Zabo will provide input tonight as requested by Mr. Buzak. Since 2019, the city has complied with the court process that is required to be followed to obtain a declaratory judgment that the city has satisfied its affordable housing obligation. No action will be taken at tonight's meeting. After Mr. Buzak's presentation, council members and the mayor will have the opportunity to ask questions. Then the meeting will be opened up for the public to comment. The city has a 3-minute public comment policy. That policy will be followed so that all members of the public will have the opportunity to be heard. The clerk will hold up her hand when there is 30 seconds left so that you will have the opportunity to conclude your statement. Neither the council nor its affordable housing attorney will engage in answering questions. All questions asked will be gathered, and the questions and answers will be posted on the city's website. It cannot be stated too strongly that if the city fails to adhere to the terms of the settlement agreement, there is the distinct possibility that Englewood will lose its immunity and protections, thereby involuntarily relinquishing its ability to control zoning and density. Thank you.
It says 5 minutes on your website.
Okay. We are now going to the presentation. Affordable Housing Planner John Zabo and COA Attorney Ed Buzak. Gentlemen.
Thank you, Council President. Good evening. My name
Excuse-
is...
Before we get started, I think that it's important that people understand and know, get a little background on each one of these gentlemen, so it gives a context in terms of their
Okay.
experience, of what they do, and what they
Sure.
have been doing.
That's a great idea.
Present.
Okay, Mr. Buzak,
Sure.
will you just tell everybody
will.
who you are?
Thank you. Good evening again. My name is Edward Buzak. I'm an attorney representing the city of Englewood as its special affordable housing attorney. My experience in the affordable housing area goes back almost 50 years. I started practicing in 1973, and one of the first cases I dealt with was an exclusionary zoning case in 1974. Mount Laurel, that everyone hears about, was decided by the Supreme Court in 1975. In 1984, I participated in a trial after what's known as Mount Laurel II before Judge Skillman for 2 weeks on behalf of a municipality. We were 3 municipalities that declined to settle that case that was brought by the public advocate at the time against 27 Morris County municipalities. In 1985, when the Fair Housing Act was adopted, which among other things created what's known as the Council on Affordable Housing, or what was known as the Council on Affordable Housing, I went to the League of Municipalities, with whom I was the assistant counsel, and suggested to them that they create an affordable housing committee to deal with the Council on Affordable Housing directly, the state agency, and be able to provide municipal input to them. I was promptly named chairman of that committee because, of course, if you suggest something like that, they turn around and look at you to do it. And I'm proud to say that I remain that chairman since 1985. In 1986, we worked with the Council on Affordable Housing with regard to the regulations they were adopting. And those regulations changed every 6 years. So they were adopted in 1987, they changed in 1993. And in 1999, they were supposed to be adopted again, revised, refined, and so forth. But they missed the deadline. And the then head of the Council on Affordable Housing attempted to change the methodology by which affordable housing obligations are established. I participated in those discussions. There were a number of meetings that were held, stakeholder meetings as they were called. And ultimately, the Council on Affordable Housing, with the support of the League of Municipalities, among others, adopted new regulations known as growth share regulations, which tied the construction of affordable housing to the growth that a municipality had, both residential growth and non-residential growth. Those regulations were challenged by an advocacy group known as the Fair Share Housing Center. I participated in drafting portions of the brief on behalf of the League that went before the Appellate Division. The Appellate Division invalidated those regulations in 2007 and sent them back to the Council on Affordable Housing to revamp. They were revamped, and the League of Municipalities, on behalf of all the municipalities in the state, decided that they were going to challenge those revised regulations. I was selected to represent the League of Municipalities in that case. We challenged those regulations. We were successful in challenging those regulations. And then the Supreme Court, that decision was appealed. The Supreme Court decided that COA should revise their regulations and eliminate this growth share concept that they had initiated back in late 2003, early 2004. The Supreme Court gave COA a short window, within which to adopt new regulations. Ultimately, there were many iterations of them, but ultimately, when they were presented finally to the Council on Affordable Housing, the council failed to adopt them by a 3-3 vote. They had 6 members present at the time. It was a 3-3 vote. No regulations were adopted. They missed the deadline that was set by the Supreme Court. The Supreme Court then declared that COA was dysfunctional and took all the cases that were before the Council on Affordable Housing and gave the municipalities the ability to go to court through what's known as a declaratory judgment process to obtain a determination that those municipalities, or a municipality, through its zoning laws, had satisfied the constitutional obligation, what's known as the Mount Laurel Constitutional Affordable Housing Obligation. There were over 300 municipalities that were before COA at the time, the Council on Affordable Housing. Most of them filed cases in the courts, so we had over 300 litigated cases in the court. And I've represented 9 or 10 municipalities through that declaratory judgment process. I've represented 4 of them in Bergen County, Englewood, Tenafly, Upper Saddle River, and Alpine. I represented 4 in Morris County. I represented 1 in Essex County. So we've become obviously very familiar with it, and this is what I've been doing my entire career. I was retained by Englewood back around 2008 or 2009, as I recall, while these regulations were still in flux, because Englewood decided that they were going to proceed with the Council on Affordable Housing and prepare what's known as a Housing Element and Fair Share Plan. That Housing Element and Fair Share Plan was prepared. It was not adopted by the Planning Board, and right after the deadline passed, the city was subjected to what's known as a builder's remedy lawsuit. And what that means is that a developer comes in and says, you, the city, have not satisfied your constitutional obligation, and you are now going to rezone my property to accommodate some portion of the obligation, to satisfy some portion of the obligation that you have. I represented the city in that case. We resolved that case. Judge Martinotti issued an opinion and gave the city what's known as a judgment of compliance and repose, saying that we did in fact satisfy our constitutional obligation. And Fair Share Housing Center, who opposed Judge Martinotti's decision, appealed that decision. That case was settled in 2014 with some revisions to the original settlement agreement that we had entered into somewhere around 2011 or 2012. And I go through that because that gets us to really, that's how we got to where we are, because under that revised judgment of compliance and repose, we were protected from those builder remedy lawsuits because the court had found that we had satisfied our constitutional obligation, but we were protected only through May 31st of 2019, roughly a 5-year period. So that gets us to today. On May 30th, 2019, we were again retained by the city and filed a declaratory judgment action, saying to the court that we, Englewood, have indeed satisfied our constitutional obligation. And we argued to the court that we satisfied that obligation through our 2014 settlement. And the fact that it only lasted for 5 years was an anomaly based upon what had happened after 2014. And we asked the court to simply extend the immunity, the protections, the judgment of compliance and repose through July 1, 2025, which has now been accepted as sort of the universal date on which everyone's protections expire who want to participate in the process. Initially, when we filed that case, the court appointed a special master, which most judges do. Special master is usually a planner, sometimes an attorney, but mostly a planner, who assists the court in reviewing the plans that are submitted on behalf of a municipality and provide the court with recommendations as to whether or not that plan indeed has satisfied the municipality's obligation. The challenge to municipalities back in 2015, when the court took over all these cases, and indeed the challenge for Englewood, was that there was no established methodology for determining what your constitutional obligation was, to quantifying it. The words were there, but the quantification, the number of units that you had to satisfy, were not. And in fact, I participated as co-counsel with my now partner, who was not my partner at the time, in 2017, before Judge Jacobson in Mercer County. We conducted a 41-day trial to establish a methodology. That methodology was opposed by Fair Share Housing Center, was opposed by the builders. And after a year from the conclusion of that trial, we finished the trial in June of 2017, and in March of 2018, Judge Jacobson rendered her decision. And that was on behalf of 5 Mercer County municipalities who funded effectively that litigation over that period of time. Judge Jacobson essentially cut the numbers in half that were being proposed by Fair Share Housing Center. And when I say that she cut them in half statewide, so it varied depending upon which municipality you were in. But interestingly, that decision in 2018 became sort of the pole star, the standard by which most municipalities were attempting to achieve their obligations. So too, after we were unsuccessful in simply extending our protections through 2025, Englewood proposed utilizing Judge Jacobson's methodology. The case started, as I said, in May of 2019. We received immunity pending the outcome of the case. And during those first several months of 2019 and into 2020, just before COVID hit, we were trying to establish how to satisfy that obligation. Now, one of the things that we had to deal with was the fact that Englewood does not have sufficient vacant land to accommodate new growth. And the regulations that govern and the methodology that we established back in Judge Jacobson's decision in 2018 took into account whether or not a municipality had sufficient land to satisfy the numerical obligation. And there was a disconnect. There was a disconnect between the numerical obligation and your ability to satisfy it through vacant land. There's a process known as a vacant land analysis, and there's a vacant land adjustment. And the result of doing that analysis, which was done by the planners for the city, was that while our obligation, numerical obligation for this round was 819 affordable units, all we could satisfy through our vacant land was 76. So our plan had to deal initially with how do we satisfy those 76. And luckily, we were able to do that with development that had already taken place or had already been approved. And I won't go into all of the details of that. It gets somewhat complicated. But the long and short of it was that we were able to satisfy those 76 realistic development potential units without any changes in existing zoning. However, if you're following the math here a little bit, there's a difference between what our obligation is, 819, and our RDP, 76. There was another little adjustment there of 95 units that we were able to carry forward from 2014. But there was an unmet need of, I believe the number was 648, if I have the math right. Is that right? Right. So we had this unmet need, that is this differentiation between the numerical number and the actual number that we were able to satisfy. And the question was, how do we satisfy that? The law says, the Fair Housing Act says, that a municipality is to address its unmet need. And that word's an important word. And we lawyers, we're wordsmiths. And that word is important because you notice that it said address. It didn't say satisfy. If we had to satisfy that need, we'd have to create zoning that would create the opportunity for 819 units by rezoning properties in this city. Rather, when they use the word address, we have much more flexibility to deal with that. And the manner in which we dealt with that in this settlement agreement that we ultimately were able to forge over that period of time from 2019 to November of 2022 involved what's known as overlay zoning. And overlay zoning is really a simple concept. Overlay zoning creates another zone over the zone that's already, over the zone to which the property is already subject. So if you're in a residential zone and you continue to have all the rights that you have under a residential zone, you could do whatever is permitted under that residential zone. But you can also, if you choose, and if you can satisfy the criteria, you can develop your property in a different way, and that is consistent with the overlay zone. So that's the general concept of an overlay zone, and that's done because we don't have to, the city does not have to effectively guarantee that there's actual zoning where the property can only be utilized for inclusionary affordable housing development. That's rezoning. We don't have to do that because this is unmet need. We only have to address it, and you address it by providing an additional option to properties in the city. And that's effectively what we did. The settlement agreement delineates a number of areas that were developed through an analysis of the city, through the planner's office, and we created these overlay zones that are superimposed on the underlying zoning that's in these various areas. The other program, just to round this out and to finish the substance of the settlement, is that we, the city, agreed that we would help facilitate the construction of another 25 affordable units by any nonprofit organization or third-party organization that was willing to develop a 100% affordable project. We would assist them, not financially at all. We made no and have no financial commitment to it, but we would consider proposals that they would make to build up to 25. Now, it didn't have to be one project of 25 affordable units. It could be a project of 4 or 5. It could be a project of 15, whatever it could be. And that process ends on July 1, 2025. So on an overall basis, that is how we began and how we got to where we are. After we settled the case, the settlement is not binding until the court reviews the settlement with that special master that I talked about at the beginning, who, by the way, participated in all of these discussions and assisted both the city and the court in terms of developing this plan that ultimately was put into this settlement agreement. The court looks at that plan and, with the assistance of the special master and the recommendations of the special master, decides whether that plan is in fact constitutionally compliant, because it is the court's role to make that determination. They interpret the Constitution, so they need to look at the plan and make the determination as to whether this plan satisfies Englewood's constitutional obligation, as the court does with every other municipality in the state that participates in this process. Every settlement agreement is subject to a fairness, it's called a fairness hearing. In this case, the court in January of this year reviewed the plan, reviewed our exhibits. This presentation that I'm giving here was effectively given to the court through witnesses and through testimony and through documents and so forth. And with the recommendation, the favorable recommendation of the special master, the court found that this settlement agreement was fair and reasonable, satisfied the constitutional obligation of the city as it relates to affordable housing, and then gave the city 120 days within which to implement that settlement agreement. So that included, among other things, adopting several ordinances, several resolutions. It included developing that overlay zoning and how that was going to be implemented, not only on density, which was in the settlement agreement, but every other aspect of development that is typically contained in a zoning ordinance. There's bulk requirements, side yard setbacks, height requirements, coverage requirements, floor area ratio requirements, a whole series of individual requirements, and they had to vary depending upon where the overlay zone was located and the densities that were going to be contained within those overlay zones. We've worked on that. We were supposed to have that done by May 10th of 2023. It became clear as we got closer to that date that we were not going to be able to implement everything. Another thing we had to implement was what's known as the Housing Element and Fair Share Plan. And you remember that from back in 2008 and 2009 when we attempted to do that and we were unable to do it in a timely fashion, and that subjected us to the Builder's Remedy lawsuit, which resulted in the first settlement. Mr. Szabo, or his office, prepared the Housing Element and Fair Share Plan. That is a plan that's adopted, considered and adopted by the Planning Board. The Planning Board held a public hearing on that Housing Element and Fair Share Plan, which again mirrored the settlement agreement that the court had approved back in January. And that night they voted in favor of that Housing Element and Fair Share Plan, and they are considering the adoption of what's known as a memorializing resolution, which memorializes the action that they've already taken. So we're in the process of doing that, and one of the things, one of the major things we did was this overlay zone, as I said. And again, the planner, with the assistance of the attorney, very little assistance of the attorney other than wordsmithing, but the planner develops the ordinance, it's reviewed in advance by everyone, and ultimately was introduced by the governing body, and will be the subject of a public hearing, as all ordinances are, on August 8th. And as the council president noted, this is not that hearing. Discussions on the substance of that overlay zoning and the details in that are the subject of a public hearing on August 8th. So anyone who's interested in that, they should attend that meeting and voice their comments, questions, or concerns that they may have, or support of the ordinance. So, Council President, that, I think, completes my report, so to speak, to the public and to the mayor and council. And I'm going to pass it to John, if I might, John Szabo, our planner, to just supplement or correct anything that any misstatement that I may have inadvertently made, and then we can pass it back to you, Council President.
Thank you very much.
Thank you.
Good evening, everyone. My name is John Szabo. I'm the Senior Associate at Burgess Associates. I am a licensed professional planner in the state of New Jersey. We're one of only 2 states that requires a licensure. And I've been licensed for over 30 years. I've been practicing planning for over 40. I'm also a certified planner and member of the American Institute of Certified Planners. This is a nationwide recognized credential in planning. Most of my professional career has been in municipal government, working for municipalities. And among the towns that I represented, I started my career at the city of Elizabeth, and I also spent over 6 years as the city planner in the city of Plainfield. So I'm familiar with cities. I enjoy working for cities, and in between other municipalities. So most of my focus has been community planning. When it comes to working at Burgess, I would say 99% of my practice is municipal. One of our clients is the Board of Adjustment of Plainfield. I have the honor and distinction of serving there as their planner, advising them on use variance and bulk variance cases for over 6 years now. So I'm familiar with the city. Part of my experience also entails writing at least, must have been over a dozen of these housing elements and fair share plans, so I'm well familiar with the regulations. I think that Mr. Buzak has given an excellent overview of the timeline, the process, what is all involved, how do we get here, and a couple of things I just wanted to piggyback on. One, this is a constitutional obligation. This is an obligation that all municipalities have in the state of New Jersey. So the city of Englewood is not alone in having to address this, unless you are an urban aid city, which is specifically exempt, like, for example, Camden, Newark, some of those communities. You need to deal with this affordable housing issue. It is a constitutional obligation, so the city does not really have the opportunity to basically say, oh, we're not going to do this. You do have an affirmative responsibility. Now, when I prepare a housing element and fair share plan, there are certain elements that go into that. The elements that go into a fair share housing plan are dictated under the Fair Housing Act that Mr. Buzak mentioned. That law was passed in 1985. And the first part of a housing element and fair share plan would be all the statistical data. You have to do a complete analysis of your community. You analyze the housing stock, you analyze the population demographics, and you look at economics as well, employment characteristics, for example. But then you have to get to the fair share part. How are you going to handle your obligation? And as Mr. Buzak had mentioned, the case that really drives the obligations thus far in the third round is the Jacobson case. And so we utilize that number because to have to relitigate what the number should be, probably wouldn't have been successful and would have been extremely lengthy and very expensive. So we needed to come up with a plan to address our 819 units. That's our what we call prospective need, your need from 1999 to 2025. There are other elements of the obligation, however. There is the prior round obligation. As Mr. Buzak had mentioned, there were other rounds. We're now in the third round. And the city of Englewood had a prior round obligation of 152 units. If you didn't satisfy that, or your prior round, it would get carried over into the third round. So if you didn't finish up what you were supposed to do in the second round, it got added. It didn't just go away. Fortunately, the city had satisfied its 152 prior round obligations, so there's no more need to deal with those units. They've been addressed. And just so the public knows, these documents that we're talking about are all on the city's website. They're out there. There's a PowerPoint that gets into how the whole process and how the plan works, why it works, and all of that. The housing element and fair share plan is also online, as well as other documents, and I would encourage you to take advantage of those documents and review them. But in sum, the prior round was satisfied. Now, there's also something called present need, and present need is really the housing stock that is in your own community, that already exists, that you have an obligation to rehabilitate and address. These are your residents, your neighbors, your neighborhoods, where if you don't meet certain criteria in terms of the structural integrity of the structure, they look at the way present need is determined is they look at the statistical data for the conditions of the housing stock, and then they come and arrive at a number. So that obligation is 380 units. Those are units that are substandard that need to be addressed within the city of Englewood. Now, we are going to get a 125-unit credit on that rehab number because of the renovations that are going on at the Tibbs Senior Center, which was which is occupied by senior citizens and being refurbished under FEMA as a result of flooding. And so that was a credit, so that 380 gets reduced by that number, but you still have to address it in your plan. And the way the city is going to address that is through creating a rehabilitation program. That program will provide funding to eligible residents, and you become eligible by virtue of satisfying certain income guidelines that are published. So if you meet this and satisfy the income requirements and you submit an application, you might be eligible for a grant to fix your home up, and that's what this program is designed to do. Where does the money come from? It comes from what's called an Affordable Housing Trust Fund. It's not taxpayer funded in the sense that it's not part of your tax bill. It's a collection on building permit fees, both on the commercial and residential end. So that fund has monies available, and the city will create a program for that. Let's talk a moment about prospective need. The city's obligation is 819 units. Without getting into all the COA math, which is confusing to everybody, the bottom line number is 640 units, and we need to address that at some point. Now, as Mr. Buzak described, there are two aspects to that number. There's the realistic development potential, and then there's unmet need. There's a recognition in the regulations that you may not have sufficient land available to satisfy the entirety of that number, 640, which is certainly the case for the city of Englewood. What my office did and what I prepared was what's called a vacant land analysis. And we went through all the properties. We searched out vacant land. It had to be a certain size. We subtract out environmental conditions, like, for example, flooding, steep slopes, historic properties that are preserved, parkland. None of that gets calculated into the number for vacant land. And we came up with a number of about 23 units. I mean, that is basically what you could support if nothing else happened based on what's available out there. So clearly you're a fully developed community. And the regs recognize that by allowing you to take what's called an adjustment. Now that's kind of a misnomer because it gives the impression that, okay, we have a realistic development potential of 76, the rest goes away because we're vacant land adjusted. No, as Mr. Buzak had said, you have to address it, but it's a different mechanism. It's not, it's more aspirational, we like to say in planning, as it is where RDP or realistic development potential is affirmative. Now, the 76 units that make up our RDP for the city are projects that are already in the pipeline. That's not always the case with a lot of municipalities. They actually have to go out and zone areas to make up for that RDP as it gets calculated. That's not the case here. So we really need to focus on now, we've satisfied RDP, our prior round, our rehab is all managed through the plan. What do we do with the 640 units? Now, there are very limited opportunities to address that kind of a number, that large, given the lack of land. So a very standard, typical way of dealing with that is to create overlay zones. And what the overlay zone does and what the regulations permit is that it creates an opportunity, but not an obligation. So when people see zoning, the fear is, oh my goodness, the city's going to take my land, they're going to put affordable housing here, I can't use my property. And none of that is accurate, none of that is true. The very nature of an overlay zone, as Mr. Buzak has explained, is that the underlying zone, the zone that exists today will exist tomorrow, will exist going forward until maybe the planning board and the council decide maybe there should be some changes to the zoning. Nothing changes. So if you have a single family home in a single family zone, or if you're living in an apartment, that will stay and remain the way it is, and you enjoy all the rights and privileges that you enjoy now under the current zoning. Now, what does it mean then when you have an overlay? Well, it means that it's an opportunity. It means that if somebody can acquire property and apply the overlay zoning, they might be entitled to build multifamily housing with an inclusion area or set aside for affordable housing. But it's not as easy as that sounds. One, there's no obligation to the city to buy any of that land in the plan, and there's no obligation for any property owner to sell the property for that kind of development. It's optional. Plus, you have to acquire at least a half an acre of land, so you have to basically accumulate parcels unless the parcel you're looking at happens to already have that amount of land available to it. But you're not done then either. You have to then go through a process called site plan. You have to make application to the planning board. And you have to adhere to the zoning requirements for that particular overlay. That means you have to meet setback, you have to meet the impervious coverage, you have to meet the building coverages, you have to meet the landscaping requirements. This ordinance that has been drafted and introduced at this point contains architectural standards that do not exist in your multifamily zones now. We upgraded the standards for these overlays to make sure that you're getting quality type development that is appropriate for the community. But it has to go through this process. So it's not an automatic thing. There's risk involved on the part of the investment, and it has to be financially viable. And a lot of the haggling that went on and a lot of the back and forth and arguments with Fair Share was how much is too much? What do we do with this? And we consistently pushed back on a lot of that because, we know we had a sense that, we wanted to preserve the character of this community as much as we can, given this tremendous obligation. And I think that for the most part, we were successful in that regard. So the only thing I would add is that, this overlay is something that is a mechanism. It's an opportunity. It may never happen. Now, I've been asked by numerous towns and many people, well, if you don't meet it now, let's say nothing happens in the overlay zone, excuse me, what happens in the fourth round? That's an excellent question. I don't know. I'm supposed to know, but I don't. Why? Because the legislature has not set forth any real guidelines for what's going to happen in the fourth round. COA is still dysfunctional. It's not activated. I suspect we're going to come back to this type of a scenario where the courts are going to handle all of these Mount Laurel cases. Keep in mind that when the Supreme Court declared COA dysfunctional, this organization, this entity, COA, Council of Affordable Housing, was created as part of the Fair Housing Act. They had certain responsibilities to make sure that the regulations were in place within the time frame of the law. And that they just weren't getting it done, and the court just got frustrated. It got thrown into the court system. There are 13 courts, vicinages, that all they do, and they're required to consider, are these Mount Laurel cases. The Supreme Court took a special interest to make sure they were courts set up to handle just this matter. Now, part of what is difficult to grasp, and it certainly is not an easy concept for me because the process changed. And what I mean by that is that when COA was functioning under rounds 1 and 2, and when the rules were published, they were publicly published. And what happened in each round was COA would engage Rutgers University. They would create obligations statewide for all the municipalities based on a lot of planning statistics and models that we don't need to get into. And they were published. Towns looked at these obligations that were published publicly, and then they set forth to prepare plans if they wanted to. It's an optional thing. So if you decided you wanted to get certification from COA, you followed their rules and you had meetings and you did it publicly and you had planning board involved in public, and it was a very open process at that time. But what happened with the decision of the Supreme Court that invalidated COA as a functioning agency and made it and then created a court system to intervene in the process, it became litigation. It became something that had to be done through courts, through filings, through a declaratory judgment action. It became legal. Once that happened, it turned the process around. And it necessarily then is occurring within the courtrooms, with the governing bodies, because the governing body has to file this declaratory judgment action. And it just changed the process completely, which is why we are where we are today. So, I just wanted the public to understand that. Now, why would the town want to participate? Why? Under rounds 1 and 2, you didn't have to. You didn't have to file an application seeking certification of your plans with COA, but you were encouraged to because municipalities didn't want to face what's called builder remedy suits. Well, what's so terrible about that? Well, you have no control. That's the biggest problem, because what happens is I have an acre of land. you haven't met your constitutional obligation, I'm going to file a builder's remedy suit, and I'm going to put 100 units on that acre, whether you like it or not. And then it goes to court, and then there's expensive trials that go on. And more often than not, municipalities lost. Because remember who the courts work for. They work under the Supreme Court's guidance. And this was a mandate that the Supreme Court gave their court system. So to avoid this scenario, because, for example, the builder's remedy uses an 80-20 ratio. For every 100 units, 80 was market, 20 had to be, that would pay for the 20 affordable units. And so you increase the density substantially with builder remedy suits rather than controlling them through an ordinance that says, this is what we're going to tolerate, this is the densities we're going to permit, and it takes into consideration, you know, where these are located and what the neighborhoods are like. So the same scenario exists under this round, third round. As Mr. Buzak indicated, I mean, you could be subject to a builder's remedy suit at any time. Right now, the city's enjoying what's called a period of immunity. No one can really sue you under a builder's remedy suit until such time as the court pulls that immunity. Then you're exposed. And that's very risky for the town. It's litigious, and you may not get the results you want. So what we are attempting to do with the housing plan and the ordinances that implement it is to control the process, at least to get through to July 2025, and protect the town in the meantime. When I presented the plan to the planning board, which adopted the Fair Share and Housing Plan in April, what I suggested to them, because you know they had the same reaction. I mean, what are we doing with this? You know, and I explained to them the same exact thing, that it's the process that's the problem. You know, the problem with Mount Laurel isn't the fact that we need affordable housing. That's a fact. We all understand that. As a planner, I understand the importance of that, not only for communities, but for our economy and everything else, and for fairness. But it's the process that is failing right now. But it is what we have. And so, as Mr. Buzek said, we go to court, and we have to be guided by the procedures of the litigation. What I suggested to the planning board is that once you get your what's called an order of compliance and repose, and what that means is that ultimately there's a public hearing, there's a court hearing, and the judge expects that everything that was in the settlement agreement will have been accomplished. We present that to the court, and the court then goes to the court-appointed master, who in this case is a planner, and they seek advice. Did they do everything? Are you satisfied that they've implemented? Yes, Your Honor, they have, presumably. And then she turns to, we have Judge Farrington, she'll turn to Fair Share Housing Center. And are you satisfied? And yeah, Your Honor, they may have a question or two, but if all goes well, as we anticipate, you get what's called an order of compliance and repose. That extends the immunity until July of 2025. What I'd suggested to the planning board is that just because you have an order of compliance and repose and an adopted housing element and fair share plan and all these ordinances, doesn't prevent you now to plan for the next round, which is right around the corner, with public input, with planning input. You have a re-examination report that you need to do by law next year, which is a perfect opportunity to meld all of this into one comprehensive review of where are you. I will tell you that I work with your 2014 master plan constantly because of the implications of the applications that come before the Board of Adjustment. The master plan becomes very important. Your master plan doesn't address certain things that I know are of a concern to this community. So what's going to come out of this re-exam process is you're going to talk about what's changed, what is it that you wanted to have changed, what haven't you addressed that we need to address and then address it, like, for example, affordable housing. And then when the fourth round comes, here it is. We don't know what the numbers are going to be. That's the big unknown right now. But you can start creating that vision going forward. So it's an opportunity as I see it. The important concept here is to get that immunity so you can be protected so that you don't get unwanted or unanticipated development results thrown at you. And then you have to throw your hands up because you fight it in court, and then you may or may not win. So that's a very, very, I just wanted to emphasize that. We're trying to control the process to protect the city from other types of development that may not be as desirable. Now, getting back to the overlays, they may or may not happen. Nothing in terms of property rights or or the existing zoning changes. Like I said, I will repeat because it's important, it's opportunity, not an obligation. And as Mr. Bruzak said, we're addressing it. And that's where we are in terms of the housing element and plan and what we've done thus far, just to supplement what Mr. Bruzak has been outlining to you.
Thank you very much. We are now prepared to open up to the public session. I want to remind you, I'm sorry. All right, I'm sorry. Before we go to the public session, I'm going to entertain questions from the council. Michael?
Thank you. I first want to thank both of you gentlemen for your tremendous work, your professionalism, and your reputations. The fact that Englewood has both of you guiding us is significant, and I think you coined it well for those that are watching this. I want to thank Mr. Cobb for making the suggestion tonight that we have a special meeting to explain this to the community. I, too, asked for a joint meeting, and we had one last week between the planning board as well as the governing body. I have 6 quick questions. It may frame some of this. I presume before I embark on them that you selected the library and certain features of the city because the city owns those properties, and as a result that would be within the city's ambit not to develop, and that was a safety spot, correct?
That's accurate, Mayor. You know, I mean, no one anticipates that the library would be sold. It's a public building. It's not obligated to be developed. The reason it's included in the overlay is because it happens to be on Engle Street, and you don't want to gerrymander the properties. You wanted to make it consistent. But there's absolutely no obligation to build on that.
So all of this came out of lawsuits, which was under the cone of silence of settlement discussions, and it was far less transparent to the community. The planning board wasn't engaged in the settlement conversations in the last years, and it's only now that we're trying to put this together that it's come to light. And I appreciate the monumental task that you have to explain to the community and to make sure that people don't get excited or abuse the facts. So here are my questions. First, the 2014 master plan, you artfully described that there are missing elements of it or insufficient. The word flooding, I don't think even appears in it, and dealing with the next round of years is something certainly the planning board in the city of Englewood has to take up. Is this overlay zone consistent with our master plan, in your professional opinion?
Excuse me, before you go any further, was it the intent that this session, we're not going to be answering questions? And are we applying that to council members as well? Because if that's the case, we should make note of your questions, and it should appear on the answers.
I don't want to give a lecture. I'm trying to understand the history of all
No,
this.
I understand, but we did make an announcement that we're not answering questions. I just want to know if that extends to members of the council.
Mr. Buzek. That would be up to Mr. Buzek to see if the questions could be answered tonight or if they had to be taken under advisement.
The quick questions, yes, no, maybe so.
I just want to
Yeah, no, I
establish the
appreciate that.
procedure, that's all.
But, again, this is useful for me too, because it's being placed in a chronological order. And you did mention just now that the master plan from 2014 had some gaps in it that need to be addressed. But is this overlay zone consistent with the tenets of our master plan, in your professional opinions?
I think the questions that deal with our settlement agreement, which is what we're really here for tonight, to explain how we got to where we are, those questions I think should be answered. If there are ancillary questions that deal with it, I think those we can.
I can ask that question before the planning board. We have, I think we have another bite at the apple, not just August 8th, but July 27th.
Yes.
I believe the planning board is having a session. I'm happy to put that off there. Were there other ways for us, gentlemen, to satisfy our obligation? One can't imagine, with the housing elements that we have in the city, 60 years, 6 decades worth of philanthropy and affordable housing for those that have low income and so forth. Were there other ways for us to satisfy this? Could we buy Evo, the property? Could we acquire property and then contain this rather than have an overlay zone that gives concern to the community?
I can answer that generally, I think, because it does relate, I believe, to the settlement agreement. There are limited ways in which you can satisfy your unmet need. Overlay zoning, as Mr. Zabel said, is a typical way to do it. Another way to do it is 100% affordable projects, which, as I said, we have as part of the settlement, we have a program in which the city will support and assist in the development of 25 100% affordable units.
That's the 125 credits for the Tibbs Center and setting up that rehab program.
No, this is
That's
different.
separate?
This is different. This is just another way in which additional units to apply against that 648 number can be achieved.
Okay.
And John, I don't know if there's.
Well, the only thing I would add to that is, if you are, yes, you can do a 100% affordable project, clearly. I know a number of communities that are doing that. One community.
But we would have to build 640.
I was gonna get to that. If you put that in your plan, and I have one community that I'm the planner for, but I was not their housing planner, I came after the housing plan, that was gonna do all 100% affordable projects. They're finding out that the buying the land, trying to get developers, it's extremely expensive. Once you put something like that in your plan, you're obligated to see it through, and it has to be built. So if there's what's called a resolution promising the bond, you know, you actually have to pass a resolution that says, if we don't finish these projects, we will bond and finish them. And then the consideration there has to be, what is the tax impact on the taxpayers getting into the affordable housing business in case an affordable housing nonprofit doesn't step forward, because you're still obligated to get that done.
So if you create it, they don't build it, then you may be stuck.
That's
And it
the
may be
risk.
too late, you'll lose your immunity then, is what you're saying.
Well, you lose your immunity, and as Mr. Zabel said, you're obligated in your settlement agreement to adopt a resolution saying, we are going to fund the building of it. One of the benefits we got in our program for the overlay zone is
have to
that
fund
we
it.
did not make that
You
commitment.
don't have to
And
fund
we
it.
do not have to fund it.
It's
We just
aspiration-
have to.
again,
And
it's
that's a
it's
major.
aspirational.
No, thank you. That was made clear this evening. I'm going to combine the next two. This is all because the legislature, in its infinite wisdom, didn't make statutes or laws requiring municipalities to do things and left it to the wild west of the courts. So if Alpine gets a better court or judge than we do, we're pushing back in litigation. We can't even share those litigative moves and tactics with the community. What about Englewood's generosity? The Actors Fund home, where they didn't allow some of the rehab to give us credit, or some of the other treasures of Englewood, in all truth, where we have affordable housing. How do we know as a governing body that the professionals here push the limits of this in litigation? You know, in other words, you came up with this overlay zone, but how do we know there aren't any other blind spot ways or housing elements that we have that haven't been accounted for?
I can answer that because, again, that relates, I think, Mayor, to the settlement agreement and also the 2014 settlement agreement. One of the big things that Fair Share opposed in the 2014 or 2010 or 11 settlement agreement that resulted in a revision in 2014 was the fact that in our plan that was approved by Judge Martinotti, we took credit for just that, for units that were built before 1980. 1980 became the cutoff point because it coincided with the census, the decennial census that preceded the adoption of the Fair Housing Act in 1985. So people went back to 1980 to see where are we, because that was the statistical information that was available. Anything built or in the affordable housing field before 1980 was not to be counted. we got Judge Martinotti, I shouldn't say we got him, we convinced him that for the reasons that you are alluding to, that Englewood was really in the forefront of this. Before this became a constitutional obligation, Englewood was producing affordable housing, dealing with low and moderate income households who needed housing. And we should be rewarded for that. We shouldn't be punished for that. And Judge Martinotti got it and gave us those credits, not all of them, but he gave us credits for things that were built before 1980. Fair Share objected to that, and we wound up modifying the settlement in 2014 to eliminate that. We have another one in now this settlement agreement related to Rock Creek, and I forgot the Park View, I think
Parkview
it is,
Terrace, yeah.
where we've done substantial rehabilitation, millions of dollars. And we attempted to, I think it's about 270 units, if my numbers are right.
You attempted to do that.
We attempted to include that in here to satisfy our obligation. Fair Share would not accept that in the settlement. What we did say, however, and what we did finally settle on, was that we have the right to claim those in the fourth round. Now, when I say claim that, I mean we can attempt to include them in the fourth round.
But we
I'm
have
sure
no
it's going to be
idea what
opposed.
that fourth round is, when it's coming, or what it'll look like. So,
That is correct.
so to my fifth question, why not push forward and litigate that? With such a robust, generous, affordable housing display in the city and history. I'm thinking of our mayor who just passed away, Sandy Greenberg. One of the last conversations I had with her in the 70s and the 80s, this was the cause celeb for the city of Englewood, adorning Route 4 in our central business district, King Gardens, Rock Creek, Parkview Terrace, and a lot of other wonderful areas. Why not push back in separate litigation on that? I mean, in other words, not now, but why not in the last year or 2 years?
Well, it's something I think that we can consider. I haven't thought that through.
Can we adopt the overlay and still push back at the same
I mean,
time?
none of that is preclusive, so yes,
So we can get our immunity, and then we could
We can
embark
deal with
on an
those issues.
aggressive lawsuit, and then we could, can you take away the overlay zone?
well, it's an option. I need to, Mayor, that's something I need to.
Is
I
that a
need to
federal
analyze
court as
carefully.
opposed to a state court mechanism? Because it's a deprivation of something. Although it's aspirational and you're creating opportunities, it's also a perceptive loss to people here who are impacted by it.
I'd have to give that more thought, Mayor.
But it is something to consider.
Certainly something to consider.
And finally, there are actors or those that are concerned that this will now be the impetus for people to develop 4,000 homes in the city of Englewood. Could somebody please address that?
And I'll handle that. Just from the planning perspective, that's, in my view, not realistic. It's not realistic. It's not been our experience doing these plans in time, and for a lot of reasons. These areas are already pretty much developed. They'd have to accumulate properties. They have to then get plans approved to build, and it's got to be it'll be market driven because there's no obligation to sell. So I think that you might get some development. I mean, that was the point of this, but in our experience, you will never approach that number.
But we
It's
can
a straight. It
still-
was a straight math calculation, and nothing more, and it's meaningless in my opinion.
You said the overlay zone creates all kinds of ancillary requirements. Does it take, we're fearful that if we don't do this, we'll get builder's remedies. Do we still have the full panoply of protections, the Board of Adjustment, the Planning Board, code enforcement, the impervious surface, building lot coverage, landscaping? Do we still have all those protections despite having an overlay zone?
Yes, you have all of those protections and all of the state regulations, wetlands, flood hazard areas.
So if you
floodplains,
keep
and so
somebody
forth,
from,
all apply.
if you keep somebody from getting more than a half an acre, you can stop a developer in their track.
They don't have sufficient land.
Right, and once they get half an acre, they still have to go through the panoply of requirements that we have.
And if they exceed impervious coverage, if they exceed their building coverage, and they're trying to sneak in extra units, it would be problematic for the developer.
So, and you would conceive that a veto of this ordinance by my good offices would imperil the city, and we could continue then to do other things if we wanted to.
All of that is correct.
Thank you, sir. Thank you.
Thank you, Mayor. Is there anyone else on the council that would like to address?
I just want to, most of my questions were answered. I just want to just say two things. First of all, I'm just going to apologize in advance. This meeting was called last minute, and I have another appointment that I have to get to, so I'm going to be leaving early. But I want to let you know that I will be watching the rest of the meeting on the YouTube.
No problem.
Thank you.
See you later.
And the second comment I want to make is that the presentation that was made last week for the planning board, the joint meeting for the planning board and the council, is really excellent. And it's very comprehensive, and it's really complicated. And I've listened to this presentation, not today's, but last week's and the prior one 3 times now. And each time I listen to the presentation, I learn more and more. And I'm going to listen to it a 4th time. So I just want to encourage everybody who's here, if you haven't listened to the presentation, please go on the city website. It's on the YouTube channel, but Yancy is going to be putting it on the website under affordable housing. And even if you've heard it once, listen to it a 2nd time. Those are my comments.
Thank you, Councilwoman. Would anyone else on the council want to say something? Question? Charles?
So, Mr. Buzet, you and Mr. Zabel, great job. I think
Thank you.
laid it out pretty straight. What troubles me is that people think that just I'm using it. So, maybe I go up to home. No, let me see. Can you hear me now? No. Huh? No? Can you hear me now? Yes. Okay. So, someone who's been on the council for a little while, we've had a number of conversations about this. What I don't want the public to feel is intimidated or getting sold short. And the reason why I asked for those 2 gentlemen to give a background is that they are the guys in their field in terms of this affordable housing. So we got the best guidance there was out here to get and how we can handle it. I think it's fear-mongering when they say the overlay and all these things that, this will happen to you. One, that 4,000 units, I beg anybody to think anybody's going to build 4,000 units in the city of Englewood. But I will say this, and I'm going to ask you this, Mr. Buzek. We missed an opportunity. There were a number of developments in the city of Englewood, major developments, that we didn't get any affordable housing in. One William, Evo, Town Center. We didn't get any affordable housing. Now, we got to ask ourselves why we didn't get that. See, now my question would be, can we go back to those developers? But, here's the play that nobody saw. Many of these developers wanted pilots in order to get affordables. So we didn't talk about that. So they want to change the tax base for us to give them, for them to give us affordable housing. So we need to deal with that. I think that we missed an opportunity, but there was an ordinance drafted 2018, myself and Councilman Hamer, about affordable housing. Before then, nobody was pressing that, before 1999 or something around there. So there are guardrails in place, I believe. And I believe the right thing to do is to move forward and not give control. Because if we give control to the developers, the builder's remedy will supersede our zoning. So we need to understand that. And we can continue to mold this, this clay, so to speak, and what I mean by that, it is the plan, the future plan. I don't like to call it the master plan, but the planning for Englewood in the future. As we put that together, we take all those considerations which you said today, I believe, as we move forward. I think we would have got Judge Farrington, if we would have been getting affordables all along, she wouldn't have took such a stance and given us a directive of what we had to do and how we had to approach that, because she would have saw the goodwill of the city. And my job as a council person is to make sure that the residents don't feel like they're gonna be penalized. And we're gonna make sure that that doesn't happen, right? With you guys' help and assistance and guidance.
Well, one of the things that I failed to mention, or I neglected to mention, was the settlement agreement also includes a mandatory set-aside ordinance that would have captured all of the things that you're talking about. When developers were getting higher density developments, they would have been required. They are now required under the orders, or will be when the ordinance is adopted. But there was that, I concur with you, there was that opportunity that was missed.
No, that's why I wanted you gentlemen to lay it out for the folks. And now it's their job to hold us accountable, to make sure that we protect their interests and making sure that it's not gonna impact anybody's residency properties in the city of Englewood. Right, rightfully so, right? That's what you said. That's what you gentlemen said tonight, right? John?
Yes.
Okay. I saw you looking at Ed. I just
No,
wanted to
I'm
make
just
sure.
listening. I mean, you're absolutely correct. I mean,
I just want to make it very clear, because I asked for the meeting, because I want to make sure that the public understands it, because I don't want this fear mongering, and I don't want people grandstanding. I just want us to be truth tellers and fact tellers to the public, because they're the bosses, right? They pay the bills here, so I want to make sure that they're comfortable with what happens, and I want them to participate in what happens here. That's why I support you two gentlemen coming here and doing that. This is important to all of us. That's why we're here today. But I want them to make sure they understand. I want them to leave here comfortable. And if they're not, it's our job to get them comfortable by August 8th on whatever questions that they may have. So whatever other guidance, please, that you guys believe that we need to get, and any kind of communications that we need to have with the public, I'm seeking your guidance on that. Thank you.
Yeah, and also the city is going to put together a frequently asked questions section with the most asked questions with the answers, right? And we're gonna get that on the city website. So that's gonna help too.
All right, I would just like to say that all of these activities and these motions and this whole affordable housing started before several of us were on the council. So unfortunately, we couldn't impact any of this prior to the time that we're serving here. And our intention is to protect the citizens and the property. And I think Mr. Buzak and Mr. Szabo made it very clear that no one is going to be forced to sell property, to do anything. We're hoping, we just want to avoid builder's immunity so that our zoning will not go flying out the window and will be left to their mercy. Anyway, is there anyone else that would like to, Kevin?
Yes. Good evening. Thank you, gentlemen, for your presentation. I think it was well weighted for. It appears that we may have some constraints, or I know I have some constraints, that, so I won't really ask questions since we're not here to get answers tonight, but these are some thoughts and concerns of mine and my constituents and citizens throughout. I think it's important to notice, how does this match our zoning ordinance? Is this part of the settlement? How does this match our neighborhood plan? context for sensitive flooding? Where is our green building sections? Who does the Englewood mapping and analysis? And why does that need to change? It was stated that everyone who viewed the plan, I'd like to know, because I am new, it's a concern of mine, who the viewers were. How do we analyze? How often does the need change? If we're fully developed, why are we required for more? What towns don't have a contract that are using builders' remedies? And how long is our immunity good for? I know these sound like questions, and we're not doing questions tonight, but I just wanted to be on the record that they're concerns. And I think that at some point, moving forward, whether I be on the planning board liaison, that we capture this information because it's so extensive, whether you're new to town or not. This is some scary information for people to be in these particular areas for the overlay. And I think it's a legitimate concern for our residents. I appreciate this for being part of our transparency. I would just like it to be continued, and I await the opportunity for questions to be answered. Thank you.
Okay. Can I open the, is that all right with the council? Can we go on to our public session? Looks,
Should we ask Mr. Buzek if there's any, if he can answer any of those questions, or do we just hold them in abeyance?
I can answer one, and that is, how long is immunity? Immunity will end on July 1, 2025. So it's about 2 years, a little
It's
under 2
very
years
short.
now that we have it.
Okay.
So we start this process again 2 years from now.
Okay.
Okay,
I
thank-
think I asked when you asked how long, who was involved. Everybody who sat on the council, at that time from 2019 till present. And right now, I would be the only person who left, I believe, on it. So we were involved. If you looked at the timeline, you would see, you would see the topics that we addressed and how we addressed them and why and who was involved in that. So, if you just go through that and you want to talk to me about it, I'll get you there. But that.
And I appreciate it, and I feel so restrained, because I know we're not supposed to be going back and forth, but there's so many questions after a question like that's answered. I'm pretty much up to speed on things, and thank you for that, Councilman. But I think there's plenty of residents out here that are listening and watching that are not, that I get constant emails and phone calls in regards to those questions, and whether they're new to town or not, they think that their area, their AOH area wasn't considered. And if it was, how was it done? So.
And that's fair, that's a fair comment. I happen to be a person that has an interest in a number of boards, as I'm the councilman at large.
Absolutely.
And I've got those same comments, but also you could be a homeowner and live in the first ward and be a homeowner in the fourth ward, which happens to be. So, but I think the thing of it is understanding the process is one thing, which we try to explain and which we will continue to explain. If I have to have meetings after meetings after meetings, I will do that until everybody gets that, because it's important to understand. But what I think that Mr. Buzek said, nobody's going to lose their house. Nobody's going to lose these things. They're going to be able to live the same way they have, and that's what's key. However, if we lose our immunity, that changes everything. It supersedes our zoning. It supersedes our control. So then they will be in trouble.
No, I'm
And
clear,
so-
I'm
so
clear on
that's-
that.
That's what I'm saying, that's what we have to be. You know, is it perfect? Absolutely not. But it is what it is, but I think that this says to us how we move forward, and you sitting on the planning board to say, hey, somebody's coming in here to develop and build, you're gonna be like, well, we better make sure that we get those affordables in there, so
Right.
that we don't have that. And what I said earlier is that we missed opportunities with these buildings that we see when we walk out of here, so we got no affordables out of that. That number would have changed.
That's very unfortunate.
Right, that's unfortunate, and that number, the number that we're talking about tonight would have been drastically different, you know, if we had got something out of each one of those at 20%.
Okay.
And thank you for that. Just real quick, Madam Chair, if I may. Thank you for sharing with that. And I'm sure there's several people listening and watching and that are here that may have the fear of losing their property or house or investment. But I think a larger or an equal concern is people losing the quality of life and the fear of the overlay and the development. I think that's a real fear for a lot of people. This building isn't what Englewood residents are used to. It's changed over the last 20 or 30 years, and a lot of people are tired of it.
If I may just add to it, and I think the councilman described it well, it's been the Wild West in recent years. I watched when I came back as mayor after the 10-year hiatus, and Mr. Cobb sat on the planning board, and you didn't have the audacity to ask, or you couldn't ask for affordable housing, and developers would ask for those pilots and for special taxation if you were to give it to them. I pushed forward on one project where the Mitchell-Simon project was, and I asked for it and insisted on it.
I want to correct you on that. Go to the record. I pushed forward, and then you piled on. That's
Which
what
one?
I-
For which?
Mitchell-Simon. Remember
Good.
that. But what I'm
We
saying
pushed
is
forward.
We still didn't get what we should have gotten. We still didn't get what we should have
Okay,
gotten.
but we
right?
can't
but-
undo the
but-
past.
But, Judith, let me just make my point, and Charles, I wasn't challenging you by this. It was the Wild West. It was literally Board of Adjustment, Planning Board, City Council meetings, and we're languishing with what we did as if we didn't do enough for the city when we stand as a bastion of comfort to people in affordable housing, and our seniors don't want to leave from here. So there is a measure of comfort that I think we draw by having something ultimately codified. But I think the best comment from the professionals I heard tonight was, use this as the impetus to get ahead of ourselves if we're going to look at our master plan all over again to fill up the gaps and to get ready for 2025, which is right around the corner, and not wait for things to happen to us as a backseat driver.
That makes a great deal of
I'd
sense.
like to make a comment.
Go ahead.
I think what the other thing about affordable is that some people confuse affordable with low-income housing, which is a different formula altogether as well, right? So we have to see, and I don't know if we do this in a survey or something, what is it that the city really needs in terms of its population, in terms of, you know, based on incomes and things of that nature, and build according to our population as opposed to building because the developer wants to make money. You know, what do the residents need here in the city of Englewood, as opposed to what somebody wants to come in and to develop a building or properties. I think that would help us as well. So I take away that this is an ongoing topic, and it's an ongoing project that we have to deal with going on, and how do we satisfy that with making sure that we cover the people of Englewood the best way we can. I believe that's what we are here to do tonight, hopefully, and understand our population more often.
Thank you, Charles. Okay, are we ready to open it up? Is there anyone else on the council? Okay, I'm opening the public session of our meeting. Anyone who has a question, a comment, once again, questions will be answered on our website. We will do the best we can to group all the questions and give you very knowledgeable answers. We need your name, your address, and you have 3 minutes We're doing this so we can hear everybody. Okay, hello.
Good evening, Amy Bullock, Howland Avenue. I have some concerns. We're talking about creating these overlay zones. Number one, I'm concerned that we have overlay zones in places like Pendle Avenue, which look like a third world country after Hurricane Ida, clearly cannot withstand additional multi-unit buildings down there. Areas in the Fourth Ward that are in flood zones is a concern, which leads to the city's infrastructure as a global entity. What are we going to do to prepare for additional fire, additional police, DPW, emergency services, if these developments come into Englewood and we start having this influx and increase in our population based on these numbers that we have to create an opportunity for? We can't withstand what we have now with our infrastructure. So what's the council's plan on ensuring that as population grows, our resources grow? I don't have a concern about losing my property. What I have a concern about, and some of you may not understand this, but I know at least 2 of you sitting up there will. For generations, certain populations have been targeted. And my concern is that once these overlay zones are in place, that developers will target certain areas and begin harassing residents about purchasing their properties, which actually happens today. But doing this gives them carte blanche at aggravating and harassing and intimidating and bullying people into buying their, or as the gentleman said, accumulating multiple parcels. So how is the city going to protect us from this type of harassment? And as I stated, at least 2 of you up there understand what I'm saying. If there are others who don't, I'll be glad to explain after the meeting because I don't want to go past our 3 minutes. But these are really serious issues, really serious concerns, and the council and the leadership and the planning board and everybody else needs to take this into consideration and provide us some guidance on what the plan is. Thank you.
Yeah, Rick Wilby, Englewood, New Jersey. There's a saying that says, how do you know when a politician is lying? When his lips are moving. Okay, and how do you know when a lawyer's lying? It's the same thing. To me, this is good old-fashioned gentrification. It's good old-fashioned redlining. And this so-called COA, Council on Affordable Housing, it's going to affect disproportionately black people again. You know, every time you pilgrims want to steal something or come into the neighborhood, you just come into the neighborhood and come up with these plans like you're doing us a favor. You're not doing us no favor. You didn't do us a favor with 1 William. You didn't do us a favor with Town Center. You didn't do us a favor with EVO. People don't even have places to park. This is completely ridiculous. This is gentrification 101, redlining 101, and this is creating a developer's paradise. What is this constitutional right that these developers have to come into people's communities and just build to where they push them out? It's kind of like the same right that the Pilgrims had when they got off the ships. Only thing is now they're not killing you, they're killing you with legislation and with stupid rules and laws and planners and lawyers and all these other people that are just talking crap in my ear. It sounds like complete nonsense. Englewood is completely overdeveloped. I wish they would develop things up in the First Ward on those acre setbacks. Those should be in the overlay zones. Those acre or 2 acre setbacks in the First and Second Ward, build there. The Fourth Ward has already been inundated with development, and people talk about what their responsibility was or wasn't. I've been coming here for about 9 years, and I've seen everybody sit back and do this while everybody got rich and did what they wanted to do to destroy the characteristics of this neighborhood. Talking about special masters and master plans. You know what a master means to me? The master's plan means to me? There is no such thing as a special master to me. You understand? For the simple fact that we know that this is not going to end well for people that look like me or people in the Fourth Ward. This is always targeted at urban areas or communities that they want to take back and do what they want to do. You talk about places like Newark and Camden where you can't even do this because you got all the Negroes where you want them anyway. So why would you go and give them something else than what they already got? This is what it is. Englewood is completely overdeveloped. It can't take one more development. It's like a damn fishbowl right now when it rains. Nobody's thinking about that. And everybody's talking about fear-mongering. The fear-mongering is being done by these so-called lawyers and these professionals that are telling us what these greedy builders are going to do to us. We pay our taxes, go spend the money, go to court and fight it and let them know we've had enough and go fly a kite someplace.
Thank you.
Hi. So I'm on Glenwood, and right near Grand Avenue. Right now I have like a residential house next to me, and that's could be rezoned to big apartment building. I just bought my house a year ago.
Please.
Oh, sorry, Esther Reidler. Yeah, so I just bought my house a year ago, and just thinking about what's going to happen if there's a big apartment building that gets built next to me, how it's going to affect just being surrounded by construction, how it's going to change the value of my house, how it's just going to affect traffic coming up and down my street. I'm already on that street that's had 2 years of, not being able to pass through it. Maybe now people will be able to pass through it and there'll be just like, a million cars going through it. So that's a concern for me. And I'm wondering if there is a big apartment building built next to my house, how will that affect, will there be any kind of compensation, or will the taxes be impacted because of that? So those are just some of my questions. Thanks.
Thanks.
Hi, I'm Ann Dermansky. I've lived in Englewood for 59 years, which seems quite incredible to me. I wanted the council to know that people who really care about Englewood have been looking at these overlays, and I have spoken to a number of people who are truly disturbed. I live in the 3rd Ward. And what I see in the 3rd Ward, we have one little commercial area. We have the best bagel store in town. Their lox, by the way, is better than Zabar's. They're wonderful. They also have red dots next to them, okay? And that means, okay, they can go, okay? And there goes our Chinese takeout, and there goes the cleaners, and there goes our tiny little commercial, our lives, okay? This changes my life. I have to go downtown to get a bagel, okay? Also, when you look at these overlays, when I see that my library, I think of it as my library, it's our library, could be in danger because of this plan, oh no, sirs. That is just extraordinary. When I first moved here, we had this little place on Palisade Avenue. I still remember it, and I know the difference, and I have lived through the growth of this town. But I don't like what's going on now, and I don't know who in the hell decided that we need 4,000 units. What about our schools? No one has mentioned the schools, Sandy Greenberg is still here with us, okay? We put in 800 affordable housing. How many school children are there? Are our schools big enough? There's not even a school in the 4th Ward. That's nuts, okay, as far as I'm concerned. I just want you, council, and you other experts to know that, yes, I respect your work, but I think you should know how deeply distressing it is to so many Englewood residents.
Good evening. Raymond Diaz, 408 Shannon Court. I'm reading from the July 11th agenda meeting that we had. On page 2, on Part B, it says the Fair Share Plan describes how the City of Englewood shall address its fair share of low and moderate income housing. Yet on Part E, down below, it says, moreover, this ordinance shall apply to all developments that contain very low and moderate income housing. Why is there a discrepancy between these two bullets. Again, the first one says low and moderate, and this one says very low, low and moderate income. What is that? Which one is it? What kind of developments are we gonna have? Hopefully it will be E, where it states all three. I don't want anybody coming back and say, yeah, but you didn't see part B. Okay, so you're excluding people down that could be eligible for that very low section. Thank you.
Thank you.
Good evening. I'm Jocelyn Jonas. I live on Glenwood Road. I share some of the concerns that have been mentioned about infrastructure, in particularly traffic being so close to the hospital. We already get a lot of that, and parking. I also have some more specific questions, like we keep talking about numbers of units, but what are the size of the units? Are they 1-bedroom units? Are they 3-bedroom units? How were these specific properties chosen to be overlay zones versus other properties in the area? What gives a particular builder standing to bring a suit? And how likely is he to be successful in light of the fact that there's no vacant lands? Can he just force some type of specific performance that a resident has to sell their house? I don't know the risk of a successful suit, given how developed we already are. I think that might be it. Thank you very much.
Thank you.
Good evening, Kevin Lake. I'll reserve my questions on the overlay.
Could we have your address?
Sure, 320 North Woodland. I'll reserve my questions on the overlay until the next meeting, but I would like to repeat tonight a suggestion that I made to the council several years ago, which might help address two issues that are facing the city. One is affordable housing, and the other is a community center. My suggestion was that the city consider transferring the property behind Liberty School to a developer to create affordable housing. In exchange, the developer would be required to convert Liberty School to a top-grade community center. It would cost the city virtually nothing to transfer the property, and in exchange, the city would gain a community center near the monument. Thank you.
Thank you.
Good evening. Martha Morales, Honeck Street. Thank you for the explanation. It's clear to me that I feel like we are Ramson. We have no saint. Either we accept it or we don't accept it. Okay? So the other thing is that in terms of the infrastructure, yes, who's going to decide where is going to this affordable housings are going to be put, and then who's going to meet the additional manpower that we're going to need for schooling, for policemen, and like Mayor Michael Weil said, it's been the Wild West. It's been the Wild West in Englewood for decades. So now, is this a guarantee that there's going to be law and order? So for example, on Honeck Street, I'm reading block 2905. I'm one of two properties there, so now I am at the mercy of the whole block, because according to this, on my street, you have the whole entire block as an overlay zone. So I'm gonna be at the mercy of these companies who wants to make a dime, make a dollar over their properties and don't even care about the small residents in that area. So who's gonna protect us as homeowners? So I'm gonna lose my quality of life because I will be at the mercy of somebody making a decision and not even care that I'm gonna be sandwiched between these big buildings when I'm already at just one or two houses. I barely, after almost 30 years living at my house, barely getting my street cleaned. So what's gonna happen now when I get all these buildings, with this residents? So who's gonna put law and order there? So I think we need to start from the foundation. How we're gonna create schoolings, how we're gonna add more manpower, hospitals, and then we can move forward. So we can't build from the top down. We need to build from the bottom up. Create your foundation. Give us something that we can grab onto, and then we can say, this is working. So, I mean, we have to say yes. We have to say yes. But I was also reading something about Englewood Cliff. Can someone explain to me what happened in Englewood Cliff? That they did not conform, and I still don't see that they are abiding by the affordable housing. So I would like to get some explanation on that. Thank you.
Thank you.
Horace Rockbear, 51 West Hamilton Avenue, Englewood, New Jersey. I have a lot of questions, but I kind of confine it down to just a few. I have a trick question. Are we living in one city or two cities? Uphill Englewood and downhill Englewood? That's a problem. Downhill is always treated badly and the worst. I agree that everyone, regardless, deserves a safe place to live regardless of income. I don't have no disagreement with that. We are talking about low-income, affordable housing, which is commonly called the projects. How does that affect the value of other properties? Now, I noticed one thing, that it's centralized through Ingle Street, Grand Avenue, downwards. A little bit on that side. He talked about density. Density meaning homes, density meaning the amount of people that reside there, density meaning the amount of traffic that is there, or parking. These are all questions I want answers to. I think before we move forward with this, the residents of this town deserve answers. The post office is also in the overlay zone. What is going to happen to that? I think that the way that this was put together is a form of bias, discrimination, and segregation. We created more issues than resolving issues based on the fact of where this was, most of these overlay zones are, most of where these overlay zones are, according to this. It would have been nice if the planner had something visual to show everyone behind me that where the plans was. I mean, a real good planner would put something there in front of everyone that says, hey, this is where the overlay zone is. So who did not see the plans before had the opportunity to see it tonight. Who did not go on the website had the opportunity to see it tonight. That is good planning. Sandy Greenberg, I know they've been talking about this since 1999. And I know it's no fault of most of you guys that are up here today, but I don't appreciate the fact that 23 years later, we're now trying to squeeze everybody into a corner to get this done. That's wrong. Sandy Greenberg, rest in peace, every single time a brownstone came up in town, she questioned about affordable housing, which never happened. One more question. We use the word constitutional a lot. We use the word obligation. And we also talked about community. This is not community. Thank you.
Thank you, Horace.
Lucy Walker, Washington Place, Englewood. Are you prepared to help us, let's say, a real estate professional who will speak to us and talk to us about how all of this is going to affect our property values? When I came to Englewood in 1967, down where the Smith Street post office is now, the whole area was residential, okay? Now, it's businesses that are no longer functioning. Why is there no overlay zone down there? Why can't it go back to being residential again? I see a fly in this ointment, and I'm sorry, I don't really agree with there's a lot of density over there in that area, so let's put some more over there. That makes no sense to us, okay? None whatsoever. One of the prime places that you should be looking is the industrial area where there is no industry anymore. Those giant buildings are empty, okay? And it used to be residential. Why can't it go back to being residential again? Another thing, I watched the presentation on YouTube. I listened to the explanations, and I'm a school teacher, so I'm a little reader. There's also something else. You're telling us, well, it's an opportunity. You don't have to do it. Then what you're really saying is, ignore all that. We're just doing this to fill it out because of the settlement. This is a smokescreen. That's what you're really telling us. But what about the real deal? Okay? Look at that industrial area. It needs to go back to being residential. It's a large area. How could you have missed it?
Hi, Laura Vogel, Marlborough Road. I can see some of my neighbors are here this evening. When I passed around the map of the proposed affordable housing overlays, and needless to say, we're all absolutely shocked that Hudson Avenue, the commercial area of Hudson Avenue, would be possibly decimated. That would include all of our stores there. That would include, according to this map, if this thing goes through, our only pharmacy in the 3rd Ward. We lost our bank. I mean, we're really kind of out there by ourselves. And I remember I listened to the webinar, very informative, and I asked, I spoke, and I said, well, where do we go for a bagel? Okay, that may seem silly, but to go to Hudson area, we have a wonderful bagel shop down there, and stores, and Walgreens, and a Chinese restaurant, and if you really care about buying that CBD stuff, you can get it there too. But it's just shocking to possibly lose all of that. That's like our own little small downtown. The traffic is impossible to go downtown as it is. And I remember saying in the webinar, what do I have to go to Palisade Avenue to get a bagel? Well, and I was told that that's not really what we're discussing. That would be at the public meeting. That's not really what we're talking about. But that's what we are talking about. We're talking about quality of life. And that would be terrible to see that happen. And that borders, that includes part of the 2nd Ward, the 1st Ward as well, all of those stores. This is about quality of life. And Lucy, you mentioned something about taxes, what happens to our taxes. Well, I remember with all the developing that's been going on, I was always hearing ratables, ratables, ratables. Has anybody here, have your taxes gone down? Your taxes have gone up with all this developing. It just keeps going up. So this is my gripe. Please, take that off the map, or else I'm going to bring more of my neighbors down. Thank you very much.
Good afternoon, good evening. Coach Duza, Brookway Ave. Okay, all I have to say, development, I was born and raised in Englewood. Development has really overpopulated the city. Like she said, Palisade Ave is crazy, especially on a Friday afternoon. You know, you can't walk down the street half the time, especially driving down the street, okay? 1 William Street right now, like you said, you walk around there now, you got dog doo-doo all over the place. It's unbelievable how they come out there and walk their dogs, let them poop, and keep on moving. They do not even pick the poop up. But you know what? If you're not walking around it, you will never know it. And I'm sure none of y'all walk around that area. You all drive through it. So you know what? It is ridiculous, and I don't see no reason why you should have more development coming to Englewood. This is a suburb town. This is not a city.
Okay, stop the development and work with the people that live here already. Thank you.
Thank you.
Good evening, Crystal Brown, Howell Road. I have just a few questions for the planner and the attorney. When you were coming up with this idea, when you were struggling with this plan, you indicated that you did several surveys and studies before you came to these conclusions. I would be very interested in seeing these surveys and studies that you implemented. I would be very curious to see how you arrived at your decision. So will this information be available to the public so we may also share in the knowledge? Thank you.
Thank you.
My name is Jules Shears, and I live on Forest Avenue, and I've been here before complaining about the building. Over by Route 4, I'm sure you know that they're building a 5-story apartment building. How do you build a 5-story apartment building in a residential area? I mean, it's unbelievable. There was a grandmother that used to live there, and when the grandmother, I guess her daughter took over, sold to someone, and what he did was he turned it into like an apartment. It didn't work out, and I think this was just an opportunity for the developer to come in. Then the development came in. They're basically, like I said, 5-story apartment building. It makes no sense to me. Before, they used to basically make catalytic converters. Did anyone do a developmental study down there, environmental study, to make sure that that area is safe? And then they're talking about putting cannabis down there. What do we need with cannabis in a residential area? 5-story apartment building that's going up. And what happens is where it's centered, there's no parking around there. So they got to go underground. So what happens to the sleet is what they call it when they're pounding. They had issues before, going back years ago, before we moved there in the 70s, where they put, it was like a lot of factories there. And the residents that lived there on Tejan Avenue and over did not want them, but they fought against it, but they basically built them anyway. So now they took some of the factory down, and now they got these apartments are going up. 5 stories with a deck, underground parking. So now people are gonna be laying in their bed. So the way they have the parking is on our side, which is in Englewood on Tejan, and people can reach out and touch it, you know, you don't even have to go across the street. So every morning, you're gonna hear with the door going up and down when people laying in the bed trying to sleep. As it is now, I just roll by there, I don't even ride around there because they got this high crane that's there. And someone needs to address that. So I'm not basically, you know, I'm not trying to speak anything to existence, but you got a high crane that's there. This thing is just floating in the air all over people's houses that are there now. They're dumping on the other side. Part of the street, basically, they went in and they only basically, you know, the other part is just, oh my God. And then they only basically kind of resurface part of it. So I have to go up the street and then go down Teaneck Road if I want to get on Route 4 because the roads down there are horrible. So you take away what we used to have. So there's not going to be a park there anymore because all you're going to have is just housing. People coming in. And they're just taking away our whole community. So was that part of the overlay also, to put a 5-story apartment building there? I'm almost finished. I just basically want someone to address that. Was that part of the overlay? And if so, why the 5-story apartment building in that area?
Excuse me, but is there anyone else that has something to say? Because if not, we're going to get a motion to adjourn the meeting. Okay, can I have a motion, please?
Before you do, Ms. Marin, just some of the questions that were asked here, particularly Ms. Demansky's, Ms. Jonas, the amount of children that are perceptively going to be brought into the community, these are things that the planners can respond to. The property values, one second, sir, the property values, in other words, perceptively, if there's development under this, that was studied by the gentleman. Can they just address the things that were asked that are permitted?
Not now.
No?
No.
On the 8th, then, they can respond?
In this country, you always say you got no numbers, you got
No, we did establish
Could I just ask
certain,
if they took
excuse
down the
me.
notes of the questions? Maybe they can develop the answers over the next week or so
That's
and
the
post them on
idea.
the website?
Yes, yes, yes.
Good.
That was the plan. We're not trying to cut anybody off, but we do need time to put together answers, and it'll be in writing, which is always easier to deal with. So, do I have a motion to adjourn the meeting?
Yeah, give a list
Second.
to the two gentlemen of the question.
We've taken care of that. Do I have a second to adjourn? Okay, roll call.
Councilman Kopp? Councilman Wilson?
Yes.
Council President Marin?
Yes. Okay, meeting is adjourned.